International and national legal framework for gender equality. The United Nations instruments provide the foundation of the international legal framework for gender equality. In its first article, the 1945 Charter of the United Nations declares that one of the UN's founding goals is to encourage respect for human rights and fundamental freedoms for all, without distinctions as to race, sex, language, or religion. The 1948 Universal Declaration of Human Rights, as a legally binding document on a customary basis, states that all human beings are born free and equal in dignity and rights without distinctions of any kind, such as race, color, sex, language, or religion. There are also the International Covenant on Civil Rights and Political Rights and the International Covenant on Social, Economical, and Cultural Rights, both of which introduce a general prohibition of discrimination in respect of the rights they regulate. The following UN instruments are directly related to the topic of women's rights: the Convention on the Elimination of All Forms of Discrimination against Women, the Convention for the Suppression of the Traffic in Persons and of the Exploitation of the Prostitutions of Others, the Convention on Consent to Marriage, Minimum Age for Marriage and Registrations for Marriage, the Convention on the Nationality of Married Women, and the Declaration on the Elimination of Violence against Women. The international framework for gender equality is further developed through the instruments of the Council of Europe, an international organization founded in 1949 to achieve greater unity among its members, based on the fundamental values such as democracy, human rights, fundamental freedoms, and the rule of law. The organization carries out its core activities through the adoption of conventions and treaties, that is, recommendations and other legal instruments such as declarations, action plans, and guidelines. The European Convention on Human Rights and its protocols, that is, the established mechanisms of its application and enforcement developed around the European Court of Human Rights, are without a doubt the most significant such instrument of the organization. Within the organization, there are many legal other instruments for protection of human rights, as well as independent monitoring mechanisms. Among these, in the Convention on Preventing and Combating Violence Against Women and Domestic Violence, better known as the Istanbul Convention. The Istanbul Convention is the most comprehensive international treaty dealing with violence against women and domestic violence as serious violation of human rights and the key outcome of the Council of Europe's work on gender equality. The main aspects of this convention are the prevention of violence, the protection of victims, and the prosecution of perpetrators. Furthermore, the Convention is the first international treaty to define gender as socially constructed roles, behaviors, activities, and attributes that a particular society considers appropriate for women and men. This definition implies that there are also socially constructed roles, behaviors, activities, and attributes that a particular society considers appropriate for women and men, as well as awareness that certain roles or stereotypes produce unwanted or harmful practices and contribute to the acceptance of violence against women. The Convention listed among the primary prevention measures as a general obligation to prevent violence, the duty to take necessary measures to eradicate prejudice, customs, tradition, and other practices based on the idea of women's inferiority or stereotypical gender roles. At the same time, the Convention calls for a gendered understanding of violence against women and domestic violence to serve as a foundation for all victim protection and victim support measures. The international framework for gender equality is complemented by the European Union's legal framework, which includes founding treaties and implementing instruments such as directives on various aspects of gender equality promotion and protection. Gender equality, for example, is recognized as one of the EU's fundamental recognized common values in the Treaty on European Union. Therefore, gender equality has become not only relevant for existing members, but also one of the criteria for determining whether a country may become an EU candidate and thus a pathway for countries aspiring to EU membership. The actual application of the gender equality principle is the responsibility of the EU complex institutional frameworks, including the European Commission, the Court of Justice of the European Union, the Council of the European Union, the Parliament of the European Union, the European External Action Service, and the European Institute for Gender Equality. The Bosnia and Herzegovina Constitution, which does not contain explicit provisions relating to the equality of women and men, but established the protection of human rights and fundamental freedoms as one of the pillars of the constitutional system, is the most important for the constitutional and legislative framework for gender equality in Bosnia and Herzegovina. The Bosnia and Herzegovina Constitution states that the enjoyment of the rights and freedoms provided for in the Constitution or in the international agreements listed in Annex 1 to the Constitution shall be secured to all persons in Bosnia and Herzegovina without discrimination. The prohibition of discrimination expressly includes the prohibition of discrimination based on sex. It is important to note that the European Convention for the Protection of Human Rights and Fundamental Freedoms and additional protocols apply directly to Bosnia and Herzegovina, and that Annex 1 lists additional agreements on human rights that are directly applicable in Bosnia and Herzegovina, including the Convention on the Elimination of All Forms of Discrimination against Women and the Convention on the Nationality of Married Women. Entity Constitution and the Statute of Brčko District additionally affirm the principle of gender equality protection, which is further developed through the law on gender equality in Bosnia and Herzegovina, the Bosnia and Herzegovina election law, and the law on prohibition of discrimination in Bosnia and Herzegovina. The aforementioned laws also establish the institutional mechanisms in charge of gender equality, which includes the Agency for Gender Equality of Bosnia and Herzegovina, the Federation of Bosnia and Herzegovina Gender Center, the Republika Srpska Gender Center, as well as the Bosnia and Herzegovina Institution of Human Rights Ombudsman as the central institution for protection against discrimination. The bodies responsible for gender equality have been established within the framework of legislative power at the Bosnia and Herzegovina entity levels, namely the Committee on Gender Equality of the House of Representatives of the Bosnia and Herzegovina Parliamentary Assembly, the Committee on the Gender Equality of the House of Representatives of the Federation of Bosnia and Herzegovina Parliament, the Committee on Gender Equality of the House of Peoples of the Federation Bosnia and Herzegovina Parliament, and the Committee on Equal Opportunities of the Republika Srpska National Assembly. The mandates of these bodies are established by the rules of procedure of the legislative bodies within which they operate and mostly pertain to supervision in the field of gender equality and women's rights. Gender action plans, special sectoral policies, and affirmative measures are the most common forms of public policy in the field of gender equality in BiH.